Question 1. The review process indicates that an applicant for an explosives license in Ontario has submitted an application that is missing detailed site plans and specific security protocol for their proposed storage facility. Which of the following approaches best addresses this implementation challenge and aligns with the Ontario Ministry of Natural Resources and Forestry's regulatory framework for explosives? Option A. The applicant should submit the incomplete application as is and wait for the MNRF to request the missing information, hoping for leniency. Option B. The applicant should immediately submit detailed site plans, comprehensive security measures, and a clear operational plan outlining how explosives will be stored and handled, ensuring all documentation directly addresses the requirements outlined in the Ontario Explosives Regulations. Option C. The applicant should contact their local MNRF inspector to explain the oversight and request an informal approval based on their previous positive interactions. Option D. The applicant should submit a brief addendum stating their commitment to general industry best practices for explosive storage and security, assuming this will satisfy the regulatory body's concerns. The correct answer is B. The applicant should immediately submit detailed site plans, comprehensive security measures, and a clear operational plan outlining how explosives will be stored and handled, ensuring all documentation directly addresses the requirements outlined in the Ontario Explosives Regulations. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent risks associated with explosives and the stringent regulatory environment governing their handling and storage. The onus is on the applicant to demonstrate not only compliance, but also a robust understanding of safety protocols and potential hazards. Misinterpreting or failing to adhere to the specific requirements of the Ontario Ministry of Natural Resources and Forestry, MNRF, explosives regulations can lead to severe penalties, including license denial, fines, and potential criminal charges. The challenge lies in navigating the detailed application process and anticipating the regulatory body's concerns regarding public safety and environmental protection. Correct approach analysis. The best approach involves meticulously gathering all required documentation, including detailed site plans, security measures, storage protocols, and proof of competency for all personnel involved in handling explosives. This comprehensive submission directly addresses the core concerns of the MNRF, which prioritizes safety, security, and responsible management of explosives. By providing clear, detailed, and verifiable information, the applicant demonstrates a proactive commitment to regulatory compliance and risk mitigation, significantly increasing the likelihood of a successful application. This aligns with the spirit and letter of the Ontario Explosives Regulations, which mandate thoroughness and transparency in all licensing processes. Incorrect approaches analysis. Submitting an incomplete application with vague descriptions of storage facilities fails to meet the detailed requirements of the Ontario Explosives Regulations. The MNRF requires precise information to assess the safety and security of the proposed storage, and such vagueness suggests a lack of diligence and understanding of the risks involved. Similarly, relying solely on general industry best practices without explicitly demonstrating how these practices meet the specific mandates of the Ontario regulations is insufficient. The regulations are prescriptive, and general adherence is not a substitute for specific compliance. Finally, assuming that a good past relationship with a local inspector negates the need for a complete and accurate application is a critical error. Regulatory compliance is a formal process, and personal relationships do not supersede legal requirements or the need for documented evidence of safety and security. Professional reasoning. Professionals facing such applications should adopt a systematic approach. First, thoroughly understand the specific regulatory framework, in this case, Ontario's explosives regulations. Second, meticulously review all application requirements, breaking them down into actionable steps. Third, gather all supporting documentation with precision and clarity. Fourth, anticipate potential concerns from the regulatory body and proactively address them in the application. Finally, maintain open communication with the regulatory authority if clarification is needed, but always ensure that all formal submissions are complete and accurate. Question 2. Examination of the data shows that a mining operation in northern Ontario requires a new explosive storage magazine to accommodate an increased inventory of blasting agents. The company has identified a potential site and has preliminary designs based on common industry standards. What is the most appropriate initial step to ensure compliance with Ontario's regulatory framework for explosives? Option A. Assume that the existing explosive storage permit for a different site can be amended to cover the new magazine. Option B. Begin construction of the magazine and then contact the MNRF to inform them of the completed facility and request a permit. Option C. Proceed with the construction of the magazine based on general industry best practices, assuming it will meet provincial standards. Option D. Submit the preliminary designs and site proposal to the Ontario Ministry of Natural Resources and Forestry, MNRF, for review and guidance on specific permitting requirements. The correct answer is D. Submit the preliminary designs and site proposal to the Ontario Ministry of Natural Resources and Forestry, MNRF, for review and guidance on specific permitting requirements. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent risks associated with explosives and the stringent regulatory environment governing their handling and storage. Ensuring compliance with the Explosives Act of Ontario and its associated regulations is paramount to public safety and preventing unauthorized access or misuse. The need to balance operational efficiency with absolute adherence to legal requirements demands careful judgment and a thorough understanding of the permitting process. Correct approach analysis. The best professional practice involves proactively engaging with the Ontario Ministry of Natural Resources and Forestry, MNRF, to understand the specific requirements for a new storage magazine. This approach ensures that the proposed design and location meet all regulatory stipulations under the Explosives Act of Ontario before any significant investment is made. It demonstrates due diligence, minimizes the risk of costly redesigns, and facilitates a smoother permitting process by aligning with the MNRF expectations from the outset. This proactive engagement is directly supported by the principles of responsible explosives management mandated by the Act, which emphasizes safety and compliance at every stage. Incorrect approaches analysis. One incorrect approach involves proceeding with the construction of the magazine based on general industry best practices without prior consultation with the MNRF. This fails to account for specific provincial requirements that may differ from general guidelines, potentially leading to a non-compliant structure. The regulatory failure lies in bypassing the mandated approval process, which is designed to ensure safety and security standards are met. Another incorrect approach is to assume that a permit obtained for a different type of explosive storage will automatically cover the new magazine. Each permit is specific to the type of explosive, quantity, and location. Failing to seek a new, specific permit for the proposed magazine and its intended contents is a direct violation of the Explosives Act of Ontario, which requires explicit authorization for each storage facility. A further incorrect approach is to delay seeking clarification from the MNRF until after the magazine is constructed. This not only creates a significant risk of non-compliance, but also suggests a disregard for the regulatory framework. The Act requires that plans and specifications be reviewed and approved before construction begins, and delaying this consultation undermines the preventative safety measures embedded within the legislation. Professional reasoning. Professionals in this field must adopt a risk-based, compliance-first mindset. The decision-making process should prioritize understanding and adhering to all applicable laws and regulations. This involves proactive communication with regulatory bodies, thorough review of legal requirements, and ensuring that all operational plans are aligned with these mandates before implementation. When in doubt, seeking expert advice or direct clarification from the governing authority is always the most prudent course of action. Question 3. Upon reviewing the inventory and upcoming project timelines for a construction firm operating in Ontario, the site supervisor discovers that several explosives permits for the storage of blasting agents are due to expire within the next 2 weeks. The firm is in the midst of a critical phase of a large infrastructure project that relies heavily on the timely use of these materials. What is the most responsible and legally compliant course of action for the site supervisor to take? Option A. Continue using the existing explosives, assuming the renewal applications will be processed in time, as the project timeline is critical and the firm has a history of successful renewals. Option B. Inform the project manager that operations involving the expiring permits must cease immediately until new permits are secured, even if it means significant project delays. Option C. Proceed with using the explosives under the assumption that a de facto grace period exists for renewals, especially given the critical nature of the project and the firm's established reputation. Option D. Immediately initiate the renewal process for all expiring permits, ensuring all required documentation and fees are submitted promptly, and communicate the status to the relevant regulatory body if any delays are anticipated. The correct answer is D. Immediately initiate the renewal process for all expiring permits, ensuring all required documentation and fees are submitted promptly, and communicate the status to the relevant regulatory body if any delays are anticipated. Explanation. This scenario presents a professional challenge due to the inherent risks associated with explosives and the stringent regulatory environment governing their handling and storage. Primary challenge lies in balancing operational efficiency with absolute adherence to safety protocols and legal requirements. Misjudgment can lead to severe legal penalties, environmental damage, and most importantly, endangerment of human life. Careful judgment is required to navigate the complexities of the Explosives Act and associated regulations in Ontario, ensuring all permits are current and storage conditions meet mandated standards. The best approach involves proactively verifying the validity of all existing explosives licenses and permits well in advance of their expiry dates. This includes cross-referencing the expiry dates with the company's inventory and plan usage, and initiating the renewal process promptly. This proactive stance ensures uninterrupted operations and demonstrates a commitment to regulatory compliance. Specifically, under Ontario's regulatory framework, the Explosives Act mandates that all licenses and permits must be current for any possession, storage, or use of explosives. Failing to renew a permit before its expiry constitutes a violation, leading to potential fines and cessation of activities. This approach aligns with the ethical responsibility to prioritize safety and legal adherence. An incorrect approach would be to assume that existing permits are automatically valid, or that a grace period exists for renewals. This assumption is dangerous and legally unsound. The Explosives Act in Ontario does not provide for automatic renewals or grace periods. Permits expire on a specific date and must be reissued. Relying on an expired permit, even if the renewal application has been submitted, is a violation. Another incorrect approach is to prioritize operational needs over permit validity, proceeding with activities while awaiting renewal. This directly contravenes the Explosives Act, which requires valid permits for all stages of explosives management. This demonstrates a disregard for legal obligations and safety protocols, potentially exposing the company and its employees to significant risks and penalties. Professionals should adopt a systematic approach to managing explosives permits. This involves establishing a robust record-keeping system that tracks all licenses and permits, including their expiry dates. Regular audits of this system should be conducted. Furthermore, a clear policy should be in place that mandates the initiation of renewal processes at least 90 days prior to expiry, allowing ample time for processing and addressing any potential issues. This proactive and systematic method ensures continuous compliance and mitigates risks associated with expired permits. Question 4. When evaluating the implementation of new explosives licensing and permit requirements in Ontario, Canada, what is the most effective strategy for ensuring full compliance with provincial regulations? Option A. Expedite the licensing and permitting process by submitting applications with minimal review of documentation to meet business deadlines. Option B. Conduct a thorough review of the Ontario Ministry of Natural Resources and Forestry's specific guidelines for explosives licensing and permitting, and engage proactively with industry stakeholders to understand practical application. Option C. Rely primarily on general industry best practices and safety manuals, assuming they encompass all necessary provincial requirements. Option D. Focus solely on Federal Explosives Act regulation, as these are generally considered comprehensive for all Canadian jurisdictions. Correct answer is B. Conduct a thorough review of the Ontario Ministry of Natural Resources and Forestry's specific guidelines for explosives licensing and permitting, and engage proactively with industry stakeholders to understand practical application. Explanation. When evaluating the implementation of new explosives licensing and permit regulations in Ontario, Canada, a key challenge arises from the need to balance public safety with the operational needs of businesses that rely on explosives. This scenario is professionally challenging because it requires a nuanced understanding of the Explosives Act and its associated regulations, as well as the specific operational realities faced by various industries, such as mining, construction, and demolition. Misinterpreting or inadequately implementing these regulations can lead to severe safety incidents, legal penalties, and significant business disruption. Careful judgment is required to ensure compliance without unduly hindering legitimate economic activity. The best approach involves a comprehensive review of the specific requirements outlined in the Ontario Ministry of Natural Resources and Forestry's guidelines for explosives licensing and permitting, coupled with proactive engagement with industry stakeholders. This includes understanding the detailed application processes, storage requirements, transportation protocols, and personnel competency standards mandated by the provincial framework. By thoroughly understanding and adhering to these specific provincial directives, businesses can ensure their operations are fully compliant, thereby minimizing risks and avoiding potential enforcement actions. This approach prioritizes a deep dive into the regulatory text and its practical implications for the specific Ontario context. An incorrect approach would be to rely solely on general industry, best practices, or guidelines from other jurisdictions, without cross-referencing them against Ontario's specific legislative requirements. While general best practices can be informative, they may not fully address the unique nuances and legal obligations imposed by the Ontario Explosives Act and its regulations. This could lead to gaps in compliance, potentially resulting in non-compliance with provincial law. Another incorrect approach is to assume that existing federal regulations under the Federal Explosives Act are sufficient and that no additional provincial-specific considerations are necessary. While federal regulations set a baseline, provincial governments often have their own specific requirements and enforcement mechanisms that must be met. Overlooking these provincial nuances can lead to a false sense of security and actual noncompliance with Ontario law. Finally, an approach that prioritizes speed of implementation over thoroughness, such as rushing through the application process without fully understanding all documentation requirements or safety protocols, is also professionally unacceptable. This haste can lead to errors, omissions, and ultimately the denial of licenses or permits, or worse, operational noncompliance that jeopardizes safety. Professionals should employ a decision-making framework that begins with identifying the specific jurisdiction and its governing legislation. This is followed by a detailed review of all applicable statutes, regulations, and official guidance documents. Next, it is crucial to consult with legal counsel or regulatory experts familiar with the specific jurisdiction's framework. Finally, a proactive approach involving communication with the relevant regulatory bodies and industry associations can help clarify any ambiguities and ensure a robust and compliant implementation strategy. Question 5. The analysis reveals that an explosives manufacturer in Ontario, Canada, has recently acquired a significant quantity of high-grade blasting agents. The company's existing storage facilities were designed and licensed for lower-hazard explosives. What is the most appropriate course of action to ensure compliance with Ontario's regulations for the storage of these new materials? Option A. Assume that the existing storage facilities, which are licensed for other explosives, are adequate for the new high-grade blasting agents, provided minor adjustments are made to internal security protocols. Option B. Proceed with storing the new blasting agents in the existing facilities while initiating a process to update the storage license, accepting the risk of non-compliance until the amendment is approved. Option C. Conduct a thorough review of the Ontario Ministry of Labour, Immigration, Training and Skills Development's regulations specific to the hazard classification of the newly acquired blasting agents, and ensure the existing or any new storage facility meets all mandated security, construction, and location requirements for that classification. Option D. Rely on informal industry, best practices, and advice from experienced colleagues to determine the suitability of the current storage arrangements for the new materials. The correct answer is C. Conduct a thorough review of the Ontario Ministry of Labour, Immigration, Training and Skills Development's regulations specific to the hazard classification of the newly acquired blasting agents, and ensure the existing or any new storage facility meets all mandated security, construction, and location requirements for that classification. Explanation. The analysis reveals a scenario where a licensed explosives manufacturer in Ontario, Canada, faces a significant implementation challenge regarding the storage of newly acquired, high-grade blasting agents. The challenge lies in ensuring compliance with the Ontario Ministry of Labour, Immigration, Training and Skills Development's stringent regulations for explosive storage, specifically concerning the classification of storage facilities and the security measures required for different types of explosives. The professional challenge stems from the potential for severe legal penalties, including license revocation and criminal charges, as well as the paramount ethical responsibility to prevent accidental detonation, theft, or misuse of dangerous materials. Misinterpreting the regulatory requirements could lead to inadequate security, improper segregation of explosive types, or failure to meet licensing conditions, all of which pose substantial risks. The best professional approach involves a thorough review and strict adherence to the Ontario Ministry of Labour, Immigration, Training and Skills Development's regulations concerning the classification and security of explosive storage. This includes accurately identifying the specific type and hazard classification of the newly acquired blasting agents, and ensuring they are stored in a facility that meets or exceeds the minimum security and construction standards mandated for that classification. This approach is correct because it directly addresses the legal obligations under Ontario's Occupational Health and Safety Act and its associated regulations pertaining to explosives. It prioritizes safety and security by aligning storage practices with the precise requirements for the specific explosive materials, thereby minimizing risk and ensuring continued license validity. An incorrect approach would be to assume that existing storage facilities, designed for lower-grade explosives, are automatically suitable for the new high-grade blasting agents without a formal reassessment. This is a regulatory failure because it bypasses the requirement to verify that the storage facility's design, location, and security measures are appropriate for the increased hazard level of the new materials. It also represents an ethical failure by potentially exposing the public and employees to undue risk. Another incorrect approach would be to rely on informal advice from industry peers or outdated internal guidelines that do not reflect the most current Ontario Ministry of Labour, Immigration, Training and Skills Development regulations. This is a regulatory failure as it deviates from the legally binding requirements and could lead to non-compliance. Ethically, it demonstrates a lack of due diligence in ensuring the highest standards of safety are maintained. A further incorrect approach would be to prioritize cost savings by attempting to modify an existing, less secure storage area to accommodate the new materials, rather than investing in a purpose-built or certified compliant facility. This is a significant regulatory and ethical failure. It demonstrates a disregard for the specific safety mandates designed to prevent catastrophic incidents and prioritizes financial considerations over the safety of people and property, which is a direct contravention of the spirit and letter of explosive safety legislation. Professionals should employ a systematic decision-making process that begins with identifying the specific regulatory framework applicable to the situation. In this case, Ontario's explosives regulations. This should be followed by a detailed assessment of the materials involved and their hazard classifications. Next, a comparative analysis of the existing storage infrastructure against the regulatory requirements for the new materials is crucial. If discrepancies exist, the professional must consult the official regulatory guidance and, if necessary, seek clarification from the relevant authorities. The decision should always prioritize full compliance with the law and the highest ethical standards of safety and security. Question 6. Comparative studies suggest that effective implementation of safety protocols for explosive storage is paramount. In Ontario, Canada, a company is planning to make modifications to its existing explosive storage magazine, including relocating internal shelving and improving ventilation systems. The contractor performing the work assures the company that these changes are standard and will not impact safety. What is the most professionally responsible course of action for the company's explosives manager? Option A. Proceed with the modifications based on the contractor's assurance, assuming that standard upgrades do not require extensive regulatory scrutiny. Option B. Delay the review of the modifications until after the work is completed, focusing on immediate operational demands. Option C. Implement the modifications and then inform the relevant provincial and federal authorities of the changes made. Option D. Proactively review the proposed modifications against the current Ontario Ministry of Labour, Immigration, training and skills development regulations, and relevant federal guidelines under the Explosives Act, Canada, to ensure full compliance before work commences. The correct answer is D. Proactively review the proposed modifications against the current Ontario Ministry of Labour, Immigration, Training and Skills Development regulations, and relevant federal guidelines under the Explosives Act, Canada, to ensure full compliance before work commences. Explanation: this scenario presents a professional challenge due to the inherent risks associated with explosives and the stringent regulatory environment governing their handling and storage in Ontario, Canada. The core difficulty lies in balancing operational efficiency with absolute adherence to safety and legal requirements. A failure to do so can result in severe legal penalties, environmental damage, and catastrophic accidents. The correct approach involves a proactive and meticulous review of all proposed storage modifications against the Ontario Ministry of Labour, Immigration, Training and Skills Development regulations concerning the storage of explosives, specifically referencing the Explosives Act, Canada, and its associated regulations as applied in Ontario. This includes consulting the most current safety guidelines and potentially seeking expert advice if the modifications are complex or novel. The justification for this approach is rooted in the principle of due diligence. Employers have a legal and ethical obligation to ensure a safe working environment, which necessitates understanding and complying with all applicable legislation. By thoroughly reviewing the proposed changes against the regulatory framework, the company demonstrates a commitment to safety and legal compliance, mitigating risks before they materialize. This proactive stance is the cornerstone of responsible explosives management. An incorrect approach would be to proceed with the modifications based solely on the contractor's assurances without independent verification. This fails to acknowledge the employer's ultimate responsibility for compliance. The regulatory framework places the onus on the licensee to ensure that storage facilities meet all prescribed safety standards. Relying on a third party's word without due diligence is a direct contravention of this responsibility and could lead to noncompliance with storage quantity limits, separation distances, or ventilation requirements, all of which are critical safety provisions. Another incorrect approach is to assume that minor modifications do not require a formal review. The Ontario regulations are comprehensive and often do not distinguish between major and minor changes when it comes to safety implications. Even seemingly small alterations could inadvertently compromise the integrity of the storage facility, its security, or its compliance with fire safety or environmental protection standards. This assumption demonstrates a lack of understanding of the strict liability inherent in explosives licensing. Finally, an incorrect approach would be to delay the review process indefinitely, prioritizing other business needs over regulatory compliance. The storage of explosives is a time-sensitive matter, and any noncompliance can have immediate and severe consequences. Postponing a necessary review, especially when modifications are being considered, creates a window of potential noncompliance and exposes the company to significant risks. Regulatory bodies expect prompt attention to matters affecting the safe storage of explosives. Professionals should employ a decision-making framework that prioritizes regulatory compliance and safety above all else when dealing with explosives. This involves 1. Identifying all applicable legislation and guidelines. 2. Conducting a thorough risk assessment for any proposed changes. 3. Seeking expert consultation when necessary. 4. Documenting all reviews, decisions, and actions taken. 5. Implementing a continuous improvement process for safety protocols. Question 7. The investigation demonstrates that a recent shipment of industrial explosives destined for a construction site in northern Ontario has arrived with several containers showing signs of minor damage to their outer seals. The site supervisor, under pressure to commence work immediately, has conducted a brief visual inspection and believes the product inside is likely still safe. What is the most appropriate immediate course of action for the company to take? Option A. Attempt to reseal the damaged containers using non-approved materials to maintain the integrity of the shipment for immediate use. Option B. Immediately halt all activities involving the affected explosives, secure the materials, and initiate a formal, documented investigation in accordance with federal and Ontario provincial regulations for explosives handling and reporting. Option C. Proceed with the shipment to the construction site after the supervisor's visual inspection, assuming the internal product remains unaffected. Option D. Dispose of the damaged containers and their contents discreetly to avoid delays and potential regulatory scrutiny. The correct answer is B. Immediately halt all activities involving the affected explosives, secure the materials, and initiate a formal, documented investigation in accordance with federal and Ontario provincial regulations for explosives handling and reporting. Explanation: the investigation demonstrates a common challenge in regulatory compliance, balancing the need for timely operational efficiency with the absolute requirement for adherence to safety protocols. In Ontario, Canada, the storage and handling of explosives are governed by strict federal and provincial regulations designed to prevent accidents and unauthorized access. The professional challenge here lies in the potential for a seemingly minor deviation from established procedures to have severe consequences, including injury, death, and significant environmental damage, as well as substantial legal penalties for the company and individuals involved. The pressure to meet production deadlines can create a temptation to bypass safety checks, making robust oversight and a strong safety culture paramount. The correct approach involves prioritizing the immediate cessation of all activities related to the affected batch of explosives and initiating a thorough, documented investigation in strict accordance with the Ontario Ministry of Labour, Immigration, Training and Skills Development's regulations concerning the storage and handling of explosives. This includes isolating the area, securing the materials, and formally reporting the incident to the relevant authorities as mandated by the Explosives Act Canada and any applicable Ontario provincial regulations. This approach ensures that the potential hazard is contained, the root cause is identified, and corrective actions are implemented to prevent recurrence, thereby upholding the highest standards of public safety and regulatory compliance. An incorrect approach would be to proceed with the shipment after a cursory visual inspection by the supervisor. This fails to acknowledge the potential for internal damage or instability that is not immediately apparent, directly contravening the principle of due diligence required under explosives legislation. Such an action bypasses the mandatory safety protocols designed to mitigate risks, potentially leading to a catastrophic event during transport or use. Another incorrect approach would be to attempt to repair or modify the affected packaging without consulting the manufacturer or obtaining specific regulatory approval. This introduces an unknown variable into the handling process and could compromise the integrity of the explosive material or its containment, violating established safety standards and potentially creating a more dangerous situation. A further incorrect approach would be to simply discard the affected batch without a formal investigation or reporting. This not only fails to identify the cause of the defect, but also prevents regulatory bodies from assessing the broader implications of such issues within the supply chain. It represents a failure to comply with reporting requirements and a disregard for the systematic approach to safety management mandated by law. Professionals should employ a decision-making framework that begins with a clear understanding of the regulatory landscape, specifically the requirements of the Explosives Act Canada and relevant Ontario provincial legislation. When a potential safety or compliance issue arises, the immediate priority must be to halt operations, secure the situation, and initiate a formal, documented investigation. This process should involve all relevant stakeholders, including safety officers and, if necessary, external experts. The decision-making process should be guided by the principle of, when in doubt, err on the side of caution, ensuring that no action is taken that could compromise safety or violate regulatory mandates. Question 8. Analysis of a company in Ontario, Canada, requiring a significant quantity of ammonium nitrate for a legitimate industrial process. What is the most responsible and legally compliant method to acquire and temporarily store this material while the formal explosives license application is being processed by Natural Resources Canada? Option A. Initiate the formal application process for the appropriate explosives license with Natural Resources Canada, detailing the intended use and storage plans, and await approval before taking possession of the ammonium nitrate. Option B. Secure a letter of intent from the supplier confirming the impending purchase and store the ammonium nitrate at the company's primary operational facility, considering this as sufficient interim documentation. Option C. Obtain a general business license for chemical supply and use this as a temporary authorization to acquire and store the ammonium nitrate while the specific explosives license is pending. Option D. Purchase the ammonium nitrate and store it at a secure, non-public location, assuming that the pending license application will be approved and this temporary possession will be overlooked. The correct answer is A. Initiate the formal application process for the appropriate explosives license with Natural Resources Canada, detailing the intended use and storage plans, and await approval before taking possession of the ammonium nitrate. Explanation: Scenario analysis. This scenario presents a professional challenge because it requires balancing the immediate need for a critical component with the stringent regulatory requirements for obtaining an explosives license in Ontario, Canada. The applicant's urgency, coupled with the potential for severe penalties for non-compliance, necessitates a meticulous and legally sound approach. Failure to adhere to the Explosives Act and its associated regulations can lead to significant fines, license revocation, and even criminal charges, impacting both the individual and the company. Correct approach analysis. The best professional approach involves proactively engaging with the Natural Resources Canada, NRCan, Explosives Regulatory Division to understand the specific licensing requirements for the intended use of the ammonium nitrate in Ontario. This includes identifying the correct license type, submitting a complete application with all supporting documentation, such as a site plan, security measures, and proof of competency, and undergoing any required inspections or background checks. This approach ensures full compliance with the Explosives Act and regulations, minimizing the risk of legal repercussions and delays. It demonstrates a commitment to safety and regulatory adherence, which are paramount in the explosives industry. Incorrect approaches analysis. One incorrect approach is to proceed with the purchase and temporary storage of the ammonium nitrate without first securing the appropriate explosives license. This directly violates Section 10 of the Explosives Act, which prohibits the possession of explosives without a license. The justification for this prohibition is public safety and security, preventing unauthorized access and potential misuse. Another incorrect approach is to rely on a general business license or a permit for a different type of chemical to cover the possession of ammonium nitrate. The Explosives Act specifically defines what constitutes an explosive and requires a dedicated explosives license for its possession, storage, and use. A general business license does not confer the authority to handle regulated explosives. A third incorrect approach is to assume that a verbal agreement with a supplier or a letter of intent is sufficient to bypass the formal licensing process. The Explosives Act mandates a formal application and approval process. Informal arrangements do not meet the legal requirements and expose the applicant to significant legal risks. Professional reasoning. Professionals in this field must adopt a proactive and compliance-first mindset. When dealing with regulated substances like explosives, the decision-making process should always begin with a thorough understanding of the applicable legislation. This involves consulting the relevant government agencies, in this case, NRCan for federal explosives regulations in Canada, and seeking clarification on all licensing and permit requirements. Prioritizing regulatory compliance over expediency is crucial to ensure safety, legality, and the long-term viability of operations. Question 9. Consider a scenario where an explosives inspector in Ontario is scheduled to conduct an on-site inspection for a new explosive storage permit application. Upon arrival, the inspector discovers that the applicant has only submitted a partial application, with several critical sections regarding security plans and emergency response procedures missing. The applicant requests the inspector proceed with the inspection, stating they will provide the missing documents later that day. What is the most appropriate course of action for the inspector to take, adhering to the Explosives Act of Ontario? Option A. Inform the applicant that the inspection cannot proceed without a complete application as per the Explosives Act of Ontario and request the applicant submit all required documentation before rescheduling. Option B. Postpone the inspection indefinitely and wait for the applicant to voluntarily submit all missing documentation without further communication. Option C. Issue a provisional permit based on the partial information and the applicant's promise to submit the full application within 24 hours. Option D. Proceed with the inspection, noting the missing information, and accept the applicant's verbal assurance that the remaining documents will be provided later. The correct answer is A. Inform the applicant that the inspection cannot proceed without a complete application, as per the Explosives Act of Ontario, and request the applicant submit all required documentation before rescheduling. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent risks associated with explosives and the stringent regulatory environment governing their handling and storage. The applicant's incomplete application and the inspector's limited time create a pressure point where a decision must be made that balances regulatory compliance, public safety, and efficient use of resources. The inspector must exercise careful judgment to avoid compromising safety or unfairly delaying a legitimate applicant. Correct approach analysis. The best professional practice involves thoroughly reviewing the application for completeness and accuracy against the requirements of the Explosives Act of Ontario and its associated regulations. This approach ensures that all necessary information is present before proceeding, thereby upholding the integrity of the licensing process and minimizing the risk of issuing a permit without full understanding of the applicant's proposed operations and safety measures. Adhering strictly to the documented requirements prevents potential safety lapses and ensures compliance with the legal framework designed to protect the public. Incorrect approaches analysis. Proceeding with the inspection without a complete application is professionally unacceptable because it bypasses a fundamental regulatory requirement. The Explosives Act of Ontario mandates specific information to be submitted for review before a license or permit can be considered. Failing to obtain this information means the inspector cannot adequately assess the applicant's suitability, the proposed storage conditions, or the safety protocols, thereby creating a significant risk to public safety and violating the spirit and letter of the law. Issuing a provisional permit based on a verbal assurance is also professionally unsound. Provisional permits, if allowed at all under the Act, would have specific criteria and a defined process for issuance, which would not be met by a simple verbal agreement. This approach circumvents the established due diligence required by the regulations and exposes the public to potential hazards without proper oversight or documented justification. Delaying the inspection indefinitely until the applicant spontaneously provides all missing information is inefficient and unprofessional. While completeness is crucial, the inspector has a responsibility to guide the process. The Act implies a structured application and review process, not a passive waiting game. This approach fails to manage the workflow effectively and could unfairly penalize an applicant who is willing to comply but may need clear direction. Professional reasoning. Professionals in this field should employ a structured decision-making process that prioritizes regulatory compliance and public safety. This involves 1. Understanding the specific requirements of the governing legislation, Explosives Act of Ontario. 2. Conducting a thorough review of all submitted documentation against these requirements. 3. Clearly communicating any deficiencies to the applicant and providing a defined path for correction. 4. Making decisions based on documented facts and regulatory mandates, not on assumptions or time pressures. 5. Balancing efficiency with due diligence, ensuring that no step in the safety-critical process is compromised. Question 10. During the evaluation of an explosive storage facility in Ontario, Canada, a company's inventory management system indicates that their current physical stock of explosives is 85% of their licensed limit. Historical usage data shows an average monthly consumption of 15% of the licensed quantity, and upcoming projects are expected to increase this consumption rate to 20% of the licensed quantity per month for the next 6 months. If the company's current explosives license expires in 12 months, and the average processing time for a license amendment to increase the licensed quantity is 4 months, what is the earliest point in time, expressed as a percentage of the license period remaining, when the company must initiate the process to amend its license to avoid exceeding its current license limit? Option A. The company must initiate the license amendment process when 100% of the license period remains. Option B. The company must initiate the license amendment process when 50% of the license period remains. Option C. The company must initiate the license amendment process when 75% of the license period remains. Option D. The company must initiate the license amendment process when 25% of the license period remains. The correct answer is B. The company must initiate the license amendment process when 50% of the license period remains. Explanation. This scenario presents a professional challenge related to the efficient and compliant management of explosive materials inventory. specifically concerning the reconciliation of physical stock against licensed quantities in Ontario, Canada. The core difficulty lies in ensuring that the company's operational needs for explosives do not inadvertently lead to exceeding the limits stipulated by their explosives license, which could result in severe legal penalties and operational disruptions. Accurate and timely inventory management is paramount for safety, security, and regulatory compliance under the Federal Explosives Act and its associated regulations, as enforced in Ontario. The correct approach involves a proactive and systematic method of forecasting future explosive needs based on historical usage data and anticipated project timelines, then comparing this forecast against the remaining license quantity. This allows for timely applications for license amendments or new licenses well in advance of any potential shortfall. Specifically, calculating the projected consumption rate and projecting the inventory level over the license period, and then comparing this projection to the license limit, is the most robust method. This aligns with the principle of responsible stewardship of explosives, ensuring that all activities remain within legal boundaries and that the company can continue its operations without interruption due to licensing issues. The regulatory framework emphasizes foresight and diligent record-keeping to prevent unauthorized possession or use of explosives. An incorrect approach would be to simply rely on the current physical inventory count and assume that as long as it is below the licensed limit, operations can continue as planned. This fails to account for future consumption and the lead time required for license amendments or new license applications. It is a reactive rather than a proactive strategy and risks operational shutdown if the licensed limit is approached or exceeded without sufficient time to rectify the situation. Another incorrect approach is to prioritize immediate project needs over the license quantity, assuming that a minor overage can be addressed retrospectively. This directly contravenes the Explosives Act, which prohibits exceeding license quantities at any time. Such an approach demonstrates a disregard for regulatory requirements and elevates operational expediency above legal and safety obligations. A further incorrect approach is to delay the application for license amendments until the current stock is nearly depleted, without considering the processing time for such applications. This creates an unnecessary risk of a gap in legal authorization to possess the required quantities of explosives. Professionals should employ a decision-making framework that integrates operational planning with regulatory compliance. This involves regularly reviewing inventory levels, forecasting future needs, understanding the lead times for regulatory processes, and maintaining open communication with regulatory authorities. A key element is the use of quantitative analysis to project inventory status against licensed limits, ensuring that any potential discrepancies are identified and addressed well in advance. Question 11. Research into the optimal process for establishing a new explosive storage magazine in Ontario, Canada, reveals several potential approaches. Given the strict regulatory environment, which of the following methods best ensures compliance with the Ontario Ministry of Labour, Immigration, Training and Skills Development's requirements for Type 2 magazines? Option A. Implement changes based on the recommendations provided by the explosive supplier, without further independent verification against provincial regulations. Option B. Utilize the storage configuration that was previously approved and compliant in another Canadian province. Option C. Adopt general industry best practices for explosive storage, assuming they align with Ontario's legal framework. Option D. Conduct a comprehensive review of the Ontario Ministry of Labour, Immigration, Training and Skills Development's regulations pertaining to the storage of explosives, focusing on the specific requirements for Type 2 magazines, including construction, security, and separation distances. The correct answer is D. Conduct a comprehensive review of the Ontario Ministry of Labour, Immigration, Training and Skills Development's regulations pertaining to the storage of explosives, focusing on the specific requirements for Type 2 magazines, including construction, security, and separation distances. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent risks associated with explosives and the stringent regulatory environment governing their handling and storage in Ontario, Canada. The core challenge lies in balancing operational efficiency with absolute adherence to safety protocols and legal requirements. Misinterpreting or overlooking specific provisions of the Ontario Ministry of Labour, Immigration, training and skills development's regulations concerning explosive storage can lead to severe consequences, including accidents, environmental damage, legal penalties, and reputational harm. The need for precise knowledge of storage requirements, including separation distances and security measures, is paramount. Correct approach analysis. The best professional practice involves a thorough review of the Ontario Ministry of Labour, Immigration, Training and Skills Development's regulations pertaining to the storage of explosives, specifically focusing on the requirements for Type 2 magazines. This approach correctly identifies the need to consult the authoritative legal framework for precise guidance. The regulations mandate specific construction standards, security measures, and separation distances from inhabited buildings, public highways, and other hazardous materials. Adhering to these detailed specifications ensures compliance, minimizes risks, and demonstrates a commitment to public safety and environmental protection, as mandated by Ontario law. Incorrect approaches analysis. Relying solely on general industry best practices without cross-referencing the specific Ontario Ministry of Labour, Immigration, Training and Skills Development's regulations is professionally unacceptable. While general practices may offer guidance, they do not supersede or guarantee compliance with provincial law. This approach risks overlooking critical, jurisdiction-specific requirements that could lead to non-compliance and potential hazards. Assuming that a previous storage arrangement that was compliant in another province or jurisdiction will automatically be compliant in Ontario is also a significant regulatory failure. Each province has its own unique legislative framework, and storage requirements for explosives can vary considerably. This assumption demonstrates a lack of due diligence and a failure to understand the territorial nature of regulatory compliance. Implementing changes based on informal advice from a supplier or a colleague without verifying against the official Ontario regulations is a dangerous practice. While suppliers may have knowledge, their advice is not a substitute for legal compliance. Similarly, informal advice from colleagues, while potentially helpful, can be outdated or inaccurate and does not absolve the individual or company from their legal obligations under Ontario law. Professional reasoning. Professionals dealing with explosives licensing and permits in Ontario must adopt a systematic approach rooted in regulatory compliance. This involves 1. Identifying the specific governing legislation, in this case, Ontario Ministry of Labour, Immigration, Training and Skills Development regulations. 2. Thoroughly researching and understanding all applicable requirements within that legislation, paying close attention to details like magazine types, construction, security, and separation distances. 3. Consulting official documentation and seeking clarification from regulatory bodies when in doubt. 4. Documenting all compliance efforts and decisions. 5. Regularly reviewing and updating knowledge as regulations evolve. This structured, legally grounded approach ensures safety, legality, and operational integrity. Question 12. Governance review demonstrates that a company operating an explosive storage facility in Ontario, Canada, is utilizing procedures for the storage and handling of explosives that have not been updated in over a decade. While no incidents have occurred, the review highlights a potential disconnect with current best practices and regulatory expectations. Considering the Explosives Act and regulations of Canada, which of the following represents the most responsible and compliant course of action for the company? Option A. Initiate a comprehensive review and update of all explosive storage and handling procedures to ensure full alignment with the current Explosives Act and regulations of Canada, actively seeking clarification from Natural Resources Canada, NR-CAN, on any ambiguities and implementing a robust training program for all personnel involved. Option B. Rely solely on the advice of an external consultant to make the necessary updates, without conducting an internal verification of the regulatory requirements. Option C. Implement minor, superficial changes to the documentation to reflect a more current appearance, without fundamentally overhauling the operational procedures themselves. Option D. Continue with the existing, outdated procedures, assuming they are sufficient because no incidents have occurred, and focus resources on other operational improvements. The correct answer is A. Initiate a comprehensive review and update of all explosive storage and handling procedures to ensure full alignment with the current Explosives Act and regulations of Canada, actively seeking clarification from Natural Resources Canada, NR-CAN, on any ambiguities and implementing a robust training program for all personnel involved. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent risks associated with explosives and the stringent regulatory environment governing their handling and storage in Ontario, Canada. The company's reliance on outdated procedures and a lack of proactive engagement with evolving regulations creates a significant compliance gap. The need to balance operational efficiency with absolute adherence to the Explosives Act and its associated regulations, particularly concerning storage and security, requires meticulous attention to detail and a commitment to continuous improvement. The potential for severe legal penalties, reputational damage, and most importantly, public safety necessitates a robust and compliant approach. Correct approach analysis. The best professional practice involves a comprehensive review and update of all explosive storage and handling procedures to align with the current Explosives Act and regulations of Canada, as applicable in Ontario. This includes actively seeking clarification from Natural Resources Canada, NRCan, on any ambiguities and implementing a robust training program for all personnel involved. This approach is correct because it directly addresses the identified deficiencies by ensuring compliance with the governing legislation, which is paramount for safe and legal operations. Proactive engagement with regulatory bodies demonstrates a commitment to best practices and risk mitigation, fulfilling the ethical and legal obligations to protect both employees and the public. Incorrect approaches analysis. One incorrect approach involves continuing with the existing, outdated procedures, assuming they are sufficient because no incidents have occurred. This is a critical regulatory failure as it ignores the explicit requirements of the Explosives Act and regulations, which mandate adherence to current standards regardless of past incident history. The absence of incidents does not equate to compliance. It merely reflects a lack of detected issues, not the absence of risk. Another incorrect approach is to implement minor, superficial changes to the documentation without fundamentally overhauling the operational procedures themselves. This is a regulatory and ethical failure because it creates a false sense of compliance. The spirit of the law requires substantive changes to practices that ensure safety and security, not just cosmetic updates to paperwork. This approach risks continued noncompliance in practice, even if the documentation appears updated. A third incorrect approach is to rely solely on the advice of an external consultant without internal verification or a thorough understanding of the regulatory requirements. While consultants can be valuable, ultimate responsibility for compliance rests with the company. This approach is flawed because it outsources critical decision-making and understanding of the law, potentially leading to misinterpretations or incomplete implementation of regulatory mandates. It fails to build internal capacity for ongoing compliance management. Professional reasoning. Professionals in this field must adopt a proactive and diligent approach to regulatory compliance. This involves establishing a systematic process for reviewing and updating procedures in line with legislative changes. When faced with potential ambiguities, seeking direct clarification from the relevant regulatory authority, NRCan in this case, is essential. Furthermore, fostering a culture of continuous learning and accountability among staff regarding explosive safety and security protocols is crucial. The decision-making framework should prioritize safety and compliance above all else, utilizing risk assessment to identify and mitigate potential hazards, and ensuring that all operational practices are demonstrably aligned with the Explosives Act and regulations. Question 13. Governance review demonstrates that the company's current procedures for obtaining and maintaining explosives licenses and permits in Ontario are largely based on historical practices and may not fully align with the latest regulatory requirements from the Ontario Ministry of Natural Resources and Forestry. What is the most professionally responsible course of action to address these findings? Option A. Initiate a comprehensive review of all explosives licensing and permitting processes, comparing them against current Ontario MNRF regulations and guidelines, and implement necessary updates to procedures and documentation. Option B. Make superficial updates to existing documentation to reflect current dates, without fundamentally altering the underlying operational processes for licensing and permitting. Option C. Continue to rely on the institutional knowledge of senior staff regarding explosives licensing and permitting, assuming their long-standing practices are still compliant with Ontario regulations. Option D. Postpone any significant procedural changes until the company undergoes a formal audit or inspection by the Ontario Ministry of Natural Resources and Forestry. Correct answer is A. Initiate a comprehensive review of all explosives licensing and permitting processes, comparing them against current Ontario MNRF regulations and guidelines, and implement necessary updates to procedures and documentation. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent risks associated with explosives and the stringent regulatory environment governing their handling in Ontario, Canada. The company's reliance on outdated processes and a lack of proactive engagement with evolving regulations creates a significant compliance risk and potential for operational disruption. The need to balance operational efficiency with absolute adherence to the Ontario Ministry of Natural Resources and Forestry, MNRF, regulations for explosives licensing and permitting requires careful judgment and a commitment to continuous improvement. Correct approach analysis. The best professional practice involves a proactive and systematic review of all explosives licensing and permitting processes against current Ontario MNRF regulations and best practices. This includes identifying any gaps, updating internal documentation, and implementing revised procedures that ensure full compliance. This approach is correct because it directly addresses the governance review's findings by prioritizing regulatory adherence and risk mitigation. It demonstrates a commitment to operating within the legal framework established by the Ontario government, which mandates strict controls over explosives to ensure public safety and security. By actively seeking to optimize processes based on current regulations, the company minimizes the risk of penalties, license revocation, and potential harm. Incorrect approaches analysis. One incorrect approach involves delaying any procedural changes until a formal audit or inspection by the MNRF. This is professionally unacceptable because it signifies a reactive rather than proactive stance towards compliance. It exposes the company to significant risks of non-compliance, potential fines, and operational shutdowns if deficiencies are discovered during an official review. Furthermore, it suggests a lack of commitment to responsible explosives management. Another incorrect approach is to implement minor, superficial changes to documentation without fundamentally reassessing the underlying processes and their alignment with Ontario's specific explosives legislation. This approach fails to address the root causes of any identified inefficiencies or compliance gaps and may not satisfy the rigorous standards set by the MNRF. It creates a false sense of security while leaving the company vulnerable to more serious compliance issues. A further incorrect approach is to rely solely on the knowledge of long-standing employees without cross-referencing with current official MNRF guidelines and licensing requirements. While experience is valuable, regulations evolve, and interpretations can change. This approach risks perpetuating outdated practices that may no longer be compliant, leading to potential regulatory breaches. Professional reasoning. Professionals in this field must adopt a mindset of continuous improvement and proactive compliance. The decision-making process should begin with a thorough understanding of the applicable regulatory framework, in this case, Ontario's explosives legislation and MNRF guidelines. When a governance review highlights potential issues, the immediate priority should be to conduct a comprehensive assessment against these regulations. This involves not just reviewing documentation, but also evaluating operational practices. The goal is to identify and rectify any deviations from legal requirements and industry best practices, ensuring that all licensing and permitting activities are robust, transparent, and fully compliant. This systematic approach safeguards the company, its employees, and the public. Question 14. The performance metrics show a consistent delay in processing new applications for explosives permits in Ontario, Canada, impacting legitimate businesses' ability to operate within regulatory timelines. Which of the following strategies would be the most effective and compliant method to address this issue? Option A. Hire additional administrative staff to handle the increased application volume, assuming the current process is adequate but simply understaffed. Option B. Expedite the review process by reducing the depth of background checks and site inspections for all new permit applications. Option C. Conduct a comprehensive review of the existing application processing workflow to identify and eliminate bottlenecks, potentially through process re-engineering and technology integration, while ensuring all safety and security requirements under the Explosives Act, Canada, and Ontario regulations are maintained. Option D. Implement a system of prioritizing applications based on the perceived urgency of the applicant's business needs, without a formal review of the underlying processing steps. The correct answer is C. Conduct a comprehensive review of the existing application processing workflow to identify and eliminate bottlenecks, potentially through process re-engineering and technology integration, while ensuring all safety and security requirements under the Explosives Act, Canada, and Ontario regulations are maintained. Explanation: the performance metrics show a consistent delay in processing new applications for explosives permits in Ontario, Canada, impacting legitimate businesses' ability to operate within regulatory timelines. This scenario is professionally challenging because it requires balancing the imperative of public safety and regulatory compliance with the operational needs of businesses. A failure to process applications efficiently can lead to non-compliance for businesses, potentially forcing them to cease operations or operate in a gray area, which undermines the very purpose of the licensing system. Careful judgment is required to identify the root cause of the delay and implement effective solutions without compromising safety standards. The best approach involves a thorough review of the current application processing workflow to identify bottlenecks and inefficiencies. This includes analyzing each step from submission to final approval, considering factors such as documentation completeness checks, background verification processes, and site inspection scheduling. The goal is to streamline these steps, potentially through technology adoption, e.g., digital submission portals, automated checks, or by reallocating resources to high-demand areas, all while ensuring that the stringent safety and security requirements mandated by the Explosives Act Canada and relevant Ontario regulations are fully met. This proactive, data-driven, and process-oriented strategy directly addresses the performance metric issue by optimizing the existing framework to improve efficiency without sacrificing regulatory integrity. An approach that focuses solely on increasing staff numbers without a concurrent review of the process risks simply adding more personnel to an inefficient system, leading to increased costs without proportional gains in speed. This fails to address potential systemic issues in documentation handling or verification protocols. Another incorrect approach would be to relax the scrutiny of applications to expedite processing. This is fundamentally flawed as it directly contravenes the core objective of the Explosives Act and its associated regulations, which prioritize public safety and security above all else. Any reduction in due diligence, such as background checks or site assessments, would create significant regulatory and ethical failures, potentially leading to the issuance of permits to unqualified individuals or entities, thereby increasing the risk of misuse or accidents. A reactive approach of only addressing delays when they become critical, without a systematic review and optimization, misses opportunities for continuous improvement and can lead to recurring problems. This fails to establish a robust and resilient permitting system. Professionals should employ a continuous improvement framework. This involves regularly monitoring performance metrics, proactively identifying potential issues, and conducting root cause analyses. When problems arise, the decision-making process should prioritize solutions that are compliant with all applicable legislation, ethically sound, and demonstrably effective in improving efficiency while upholding safety and security standards. This often involves a combination of process analysis, stakeholder consultation, and the strategic application of resources and technology. Question 15. System analysis indicates that an inspector in Ontario, Canada, is reviewing an application for an explosives license. The applicant has submitted most of the required documentation, but several critical sections are incomplete, and the proposed storage site has not yet undergone a full safety inspection. The inspector has a backlog of applications and limited time. Which of the following approaches best optimizes the process while ensuring strict adherence to regulatory requirements? Option A. Reject the application outright due to the incomplete submission and advise the applicant to reapply once all requirements are fully met. Option B. Approve the license based on the submitted information, assuming the applicant will rectify the missing details and pass the inspection in due course. Option C. Thoroughly review the application, identify all deficiencies, communicate them clearly to the applicant with a defined deadline for correction, and schedule a full safety inspection before proceeding. Option D. Issue a provisional license with stringent conditions, allowing the applicant to operate while completing the remaining documentation and inspections. The correct answer is C. Thoroughly review the application, identify all deficiencies, communicate them clearly to the applicant with a defined deadline for correction, and schedule a full safety inspection before proceeding. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent risks associated with explosives and the stringent regulatory environment governing their handling and storage in Ontario, Canada. The applicant's incomplete application and the inspector's limited time create a tension between efficient processing and thorough due diligence. Failure to adhere to the Explosives Act and its associated regulations could result in severe penalties, including fines, license revocation, and potential harm to public safety. The inspector must balance the need for timely service with the absolute imperative of ensuring all legal requirements are met before granting a license. Correct approach analysis. The best professional practice involves meticulously reviewing the application against the requirements of the Ontario Ministry of Labour, Immigration, Training and Skills Development, specifically the regulations under the Explosives Act. This includes verifying the completeness of all submitted documentation, confirming the applicant's qualifications and suitability, and ensuring the proposed storage facilities meet all safety and security standards mandated by provincial and federal law. The inspector must then communicate clearly with the applicant regarding any deficiencies and provide a defined period for correction, adhering to established procedural fairness principles. This approach ensures compliance with legal obligations, upholds public safety, and maintains the integrity of the licensing process. Incorrect approach is analysis. One incorrect approach would be to approve the license based on the partial information provided, assuming the missing details are minor or can be rectified later. This directly violates the Explosives Act's requirement for a complete and accurate application before a license can be issued. It bypasses essential safety checks and exposes the public to undue risk, constituting a serious regulatory failure and an ethical lapse in professional duty. Another incorrect approach would be to summarily reject the application without providing the applicant an opportunity to correct the deficiencies. While thoroughness is crucial, procedural fairness dictates that applicants should be informed of any shortcomings and given a reasonable chance to comply. An outright rejection without this opportunity could be challenged and demonstrates a lack of adherence to administrative justice principles, even if the ultimate goal is safety. A further incorrect approach would be to grant a provisional license with significant conditions that effectively shift the burden of compliance onto the applicant without proper oversight. While conditions can be imposed, a provisional license should not be a substitute for a complete and compliant initial application. This approach risks creating a loophole that undermines the intent of the licensing framework and could lead to unsafe practices going unaddressed. Professional reasoning. Professionals in this field must adopt a risk-based, compliance-focused decision-making framework. This involves 1. Understanding the specific regulatory landscape, Explosives Act and related Ontario regulations. 2. Prioritizing public safety and security above all else. 3. Applying procedural fairness consistently. 4. Documenting all interactions and decisions meticulously. 5. Seeking clarification or guidance from senior colleagues or legal counsel when faced with ambiguity. In this scenario, the inspector's primary duty is to ensure the applicant meets all legal prerequisites for handling explosives, and this cannot be compromised by time pressures or incomplete submissions. Question 16. Which approach would be most professionally sound for a construction company in Ontario, Canada, needing immediate access to blasting explosives for a critical infrastructure project, but currently lacking the required explosives license? Option A. Diligently complete and submit a comprehensive application for an explosives license to the relevant Ontario authorities, providing all required documentation and undergoing all necessary background checks, while exploring alternative, non-explosive methods or temporary project delays if immediate access is not feasible. Option B. Proceed with the purchase of the explosives from a supplier and assume that the license will be granted retroactively once the application is filed. Option C. Arrange for an unlicensed associate to purchase the explosives on behalf of the company, with the understanding that the license application will be submitted shortly thereafter. Option D. Misrepresent the intended use of the explosives on the license application to expedite the approval process, claiming they are for a less regulated purpose. Correct answer is A. Diligently complete and submit a comprehensive application for an explosives license to the relevant Ontario authorities, providing all required documentation and undergoing all necessary background checks, while exploring alternative, non-explosive methods or temporary project delays if immediate access is not feasible. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires balancing the immediate need for a critical component with the stringent regulatory requirements for obtaining an explosives license in Ontario, Canada. Failure to adhere to the licensing process can lead to severe legal penalties, including fines and imprisonment, and compromise public safety. The applicant's urgency, while understandable, cannot override the legal obligations designed to prevent misuse of explosives. Correct approach analysis. The best professional practice involves meticulously following the established licensing procedures as outlined by the Ontario Ministry of Labour, Immigration, Training and Skills Development, specifically the regulations governing explosives. This means completing the application form accurately, providing all necessary supporting documentation, undergoing background checks, and demonstrating a legitimate need for the explosives. This approach ensures compliance with the Explosives Act Canada and Ontario's specific regulations, prioritizing safety and accountability. It directly addresses the legal framework by submitting a complete and compliant application before any acquisition or use is contemplated. Incorrect approaches analysis. One incorrect approach involves attempting to acquire the explosives through an unlicensed third party. This circumvents the licensing process entirely and is a direct violation of the Explosives Act. It creates a significant risk as the third party may not be vetted, and the explosives could fall into unauthorized hands, posing a severe public safety threat. This approach demonstrates a disregard for regulatory oversight and accountability. Another incorrect approach is to proceed with the purchase and assume a license will be granted retroactively. This is a proactive violation of the law. The Explosives Act mandates that a license must be obtained prior to the acquisition or possession of explosives. This approach ignores the fundamental requirement of pre-authorization and exposes the individual and potentially others to legal jeopardy and safety risks. A further incorrect approach is to misrepresent the intended use of the explosives on the license application to expedite the process. This constitutes fraud and is a serious offense. It undermines the integrity of the licensing system, which relies on truthful information to assess risk and ensure responsible handling. Such deception not only carries severe legal consequences, but also erodes trust in the applicant and the regulatory process. Professional reasoning. Professionals facing such situations should adopt a structured decision-making process. First, they must identify and understand all applicable legal and regulatory requirements. Second, they should assess the risks associated with each potential course of action, prioritizing public safety and legal compliance. Third, they should consult with legal counsel or regulatory experts if there is any ambiguity. Finally, they must choose the path that ensures full adherence to the law, even if it involves a longer timeline, thereby safeguarding both themselves and the public. Question 17. Investigation of an explosives license application in Ontario, Canada, reveals a potential discrepancy between the applicant's self-reported history and publicly accessible records regarding past regulatory infractions. What is the most appropriate course of action for the licensing authority to ensure compliance with the Explosives Act and safeguard public safety? Option A. Immediately reject the application due to the suspected incomplete or inaccurate information, without further investigation or opportunity for the applicant to respond. Option B. Issue the explosives license as submitted, assuming the applicant has provided accurate information and noting the potential discrepancy internally for future reference. Option C. Proceed with the license issuance while flagging the discrepancy for a subsequent, less urgent review by a different department. Option D. Conduct a comprehensive verification of the applicant's history by cross-referencing their submitted information with official databases and records pertaining to past convictions and regulatory violations within Ontario. Correct answer is D. Conduct a comprehensive verification of the applicant's history by cross-referencing their submitted information with official databases and records pertaining to past convictions and regulatory violations within Ontario. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent risks associated with explosives and the stringent regulatory environment governing their handling and storage in Ontario, Canada. The applicant's incomplete and potentially misleading information on the application form creates a significant compliance risk. A failure to accurately disclose all relevant information could lead to the issuance of a license to an individual who may not meet the safety and security standards mandated by the Explosives Act and its associated regulations in Ontario. This requires careful judgment to balance the applicant's right to apply with the public safety imperative. Correct approach analysis. The best professional practice involves a thorough verification of the applicant's information, specifically cross-referencing the provided details with official records concerning past convictions or regulatory violations in Ontario. This approach directly addresses the potential discrepancies and ensures that the licensing authority has a complete and accurate understanding of the applicant's background, as required by the Explosives Act. This meticulous verification process is crucial for upholding the public safety objectives embedded within the legislation, preventing the unauthorized or unsafe possession of explosives. Incorrect approaches analysis. One incorrect approach involves accepting the application at face value without independent verification, assuming the applicant has provided truthful information. This fails to meet the due diligence requirements mandated by the Explosives Act, which places a responsibility on the licensing authority to ensure applicants are fit and proper persons. It bypasses essential safety checks and could lead to a license being granted to an unsuitable individual. Another incorrect approach is to immediately reject the application based solely on the suspicion of incomplete information, without providing the applicant an opportunity to clarify or correct the submission. While thoroughness is vital, procedural fairness is also an ethical consideration. This approach might unfairly penalize an applicant for an unintentional error and does not align with a process designed to assess suitability after due diligence. A further incorrect approach is to proceed with the license issuance while noting the potential discrepancy internally without taking concrete steps to resolve it. This creates an unacceptable compliance gap. The Explosives Act requires accurate and complete information for licensing decisions, and ignoring a known potential issue undermines the integrity of the licensing system and compromises public safety. Professional reasoning. Professionals in this field must adopt a systematic and risk-based approach. This involves understanding the regulatory framework, Explosives Act and relevant Ontario regulations, identifying potential red flags in applications, and implementing robust verification procedures. The decision-making process should prioritize public safety and regulatory compliance, while also ensuring procedural fairness to applicants. When discrepancies arise, the professional standard is to investigate, seek clarification, and make an informed decision based on verified facts, rather than making assumptions or ignoring potential issues. Question 18. Assessment of an explosives license renewal application for a quarry operation in Ontario, Canada, requires a diligent approach to ensure continued adherence to safety and security protocols. Which of the following actions best represents the most responsible and compliant process for evaluating this renewal? Option A. Conduct a thorough review of the applicant's submitted renewal application, cross-referencing it with their existing license conditions, recent inspection reports, and any relevant incident logs to verify ongoing compliance with all safety, security, and storage requirements. Option B. Deny the renewal application due to a minor administrative error in the submitted paperwork, such as a missing signature on a supplementary form, without contacting the applicant for correction. Option C. Approve the renewal application immediately upon receipt, relying on the applicant's written confirmation that they have maintained all necessary safety and security standards since their last inspection. Option D. Grant the renewal with significantly reduced security and storage conditions, assuming the applicant's long history of safe operations negates the need for stringent oversight. The correct answer is A. Conduct a thorough review of the applicant's submitted renewal application, cross-referencing it with their existing license conditions, recent inspection reports, and any relevant incident logs to verify ongoing compliance with all safety, security, and storage requirements. Explanation. Scenario analysis. This scenario presents a professional challenge related to the responsible management of explosives, specifically concerning the renewal of a license in Ontario, Canada. The challenge lies in balancing the applicant's operational needs with the stringent safety and regulatory requirements mandated by the Ontario Ministry of Natural Resources and Forestry, MNRF, under the Federal Explosives Act and its associated regulations. Ensuring compliance while facilitating legitimate business operations requires a thorough understanding of the renewal process, the applicant's current practices, and any potential risks. Careful judgment is required to avoid both undue delays and the approval of a license that could compromise public safety or environmental integrity. Correct approach analysis. The best professional practice involves a comprehensive review of the applicant's submitted renewal application, cross-referencing it with their existing license conditions, recent inspection reports, and any relevant incident logs. This approach prioritizes verifying that the applicant continues to meet all the safety, security, and storage requirements stipulated by the Ontario MNRF and federal regulations. It involves proactively identifying any discrepancies or areas of concern that may require further investigation or clarification before license renewal. This meticulous verification ensures that the applicant's operations remain compliant and that the renewal process is grounded in factual evidence of ongoing adherence to the law, thereby upholding public safety and environmental protection as paramount. Incorrect approach is analysis. One incorrect approach involves automatically approving the renewal based solely on the applicant's assertion of continued compliance, without independent verification. This fails to uphold the regulatory duty to ensure ongoing adherence to safety standards, potentially overlooking critical issues that may have arisen since the last inspection. It bypasses the necessary due diligence required by the Explosives Act and Ontario regulations, creating a significant risk to public safety and the environment. Another incorrect approach is to deny the renewal outright due to minor administrative oversights in the application, such as a slightly delayed submission of a non-critical document, without first engaging the applicant to rectify the omission. This demonstrates a lack of procedural fairness and an overly rigid interpretation of administrative requirements, potentially hindering a legitimate business without a clear safety or security justification. It fails to consider the spirit of the regulations, which aim to ensure safe and secure operations, not to penalize minor administrative errors that can be easily corrected. A third incorrect approach is to approve the renewal with significantly relaxed conditions, assuming the applicant's past good record is sufficient. This ignores the dynamic nature of safety and security risk associated with explosives and the requirement for continuous adherence to current regulations. It fails to account for potential changes in the applicant's operations, storage, or personnel that might necessitate updated or more stringent conditions to maintain compliance with the Explosives Act and Ontario's specific requirements. Professional reasoning. Professionals in this field must adopt a systematic and evidence-based decision-making process. This involves 1. Thoroughly understanding the specific regulatory framework, in this case, the Federal Explosives Act and Ontario's provincial requirements. 2. Meticulously reviewing all submitted documentation against these regulations and historical data. 3. Proactively identifying potential risks and compliance gaps. 4. Engaging with the applicant to clarify any ambiguities or address deficiencies in a fair and procedurally sound manner. 5. Making a decision based on a comprehensive assessment of compliance and risk, prioritizing public safety and environmental protection. Question 19. Governance review demonstrates that a company operating multiple industrial sites across Ontario relies on a single, decade-old explosive storage permit. This permit was originally issued for a specific facility that has since undergone significant expansion and now houses operations at 3 distinct locations within a 50-kilometer radius, each with varying security protocols and proximity to residential areas. What is the most appropriate course of action to ensure continued compliance with Ontario's explosives regulations? Option A. Conduct a thorough site-by-site assessment of all operational locations to determine specific storage and handling needs, and then apply for new or amended permits that accurately reflect the current operational profile and comply with all relevant Ontario Ministry of Natural Resources and Forestry regulations. Option B. Immediately cease all explosives-related activities at the 2 newer locations and await further guidance from the Ontario Ministry of Natural Resources and Forestry on how to proceed with permitting for these sites. Option C. Attempt to informally update the existing permit by submitting a letter to the Ontario Ministry of Natural Resources and Forestry detailing the expanded operations and requesting an addendum to cover the additional sites. Option D. Assume the existing permit, being for explosives, implicitly covers all company-owned sites involved in related activities, as long as the total quantity of explosives stored does not exceed the original permit's aggregate limit. The correct answer is A. Conduct a thorough site-by-site assessment of all operational locations to determine specific storage and handling needs, and then apply for new or amended permits that accurately reflect the current operational profile and comply with all relevant Ontario Ministry of Natural Resources and Forestry regulations. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent risks associated with explosives and the stringent regulatory environment governing their handling and storage. The company's reliance on a single, outdated permit for multiple operational sites, each with potentially different storage requirements and proximity to sensitive areas, creates a significant compliance risk. The pressure to maintain operational continuity without compromising safety or legal standing necessitates a proactive and thorough approach to licensing. Careful judgment is required to balance business needs with the absolute priority of public safety and regulatory adherence. Correct approach analysis. The best professional practice involves a comprehensive review of all operational sites and their specific storage and handling needs against the current regulatory framework for explosives in Ontario. This approach prioritizes identifying any discrepancies between existing permits and current operational realities. It then involves proactively seeking updated or new permits that accurately reflect the company's activities across all locations, ensuring compliance with the Ontario Ministry of Natural Resources and Forestry's regulations regarding the storage, transportation, and use of explosives. This method directly addresses the identified compliance gap and mitigates future risks by aligning operations with current legal requirements. Incorrect approach is analysis. One incorrect approach involves assuming the existing permit is sufficient for all sites, despite differing operational profiles. This demonstrates a failure to understand or apply the principle of site-specific licensing, which is crucial for explosives permits. Regulatory failure occurs because permits are tied to specific locations and conditions, and operating outside these parameters, even with an existing permit, constitutes a violation of the Ontario Ministry of Natural Resources and Forestry's regulations. This approach risks significant penalties, including fines and license revocation. Another incorrect approach is to delay seeking updated permits until an inspection or incident occurs. This reactive stance is professionally negligent and ethically unsound when dealing with hazardous materials. It signifies a disregard for proactive risk management and a failure to uphold the duty of care mandated by explosives legislation in Ontario. Such a delay can lead to immediate operational shutdowns and severe legal repercussions, as regulatory bodies expect continuous compliance, not remediation after a breach. A third incorrect approach is to attempt to modify the existing permit to cover all sites without a formal amendment process. This misrepresents the company's operational status to the regulatory authority and bypasses the necessary safety and suitability assessments for each new location. It is a direct contravention of the Ontario Ministry of Natural Resources and Forestry's procedures for permit applications and amendments, which are designed to ensure that all aspects of explosives handling are properly evaluated and approved. This can be interpreted as an attempt to deceive regulatory authorities and carries severe penalties. Professional reasoning. Professionals in this field must adopt a proactive and diligent approach to licensing and permitting. This involves understanding that regulatory requirements are dynamic and site-specific. A robust decision-making framework includes regular internal audits of compliance, staying abreast of legislative changes, and engaging with regulatory bodies to clarify requirements. When faced with potential noncompliance, the immediate priority should be to rectify the situation through proper channels, even if it incurs temporary operational inconvenience or cost. The overarching principle is to prioritize safety and legal adherence above all else. Question 20. Market research demonstrates a projected increase in demand for industrial explosives in Northern Ontario over the next 12 months. A company holds an explosives manufacturing license that permits the production of up to 50,000 kilograms of Class 1 explosives per licensing year. The company's current inventory is 5,000 kilograms. The projected demand for the next 12 months is 60,000 kilograms. Assuming the licensing year begins in 1 month, what is the maximum quantity of explosives the company can plan to manufacture and sell over the next 12 months while remaining compliant with its current license? Option A, The company can plan to manufacture and sell 55,000 kilograms of explosives over the next 12 months, as the projected demand is higher, and they can adjust their production to meet it. Option B. The company can plan to manufacture and sell 60,000 kilograms of explosives over the next 12 months, as this is the projected demand, and they should prioritize meeting customer needs. Option C. The company can plan to manufacture and sell a maximum of 45,000 kilograms of explosives over the next 12 months, as this, combined with the current inventory, will not exceed the licensed limit of 50,000 kilograms for the licensing year. Option D. The company can plan to manufacture and sell up to 50,000 kilograms of explosives over the next 12 months, as the license permits this quantity within the year, and the current inventory is separate. Correct answer is C. The company can plan to manufacture and sell a maximum of 45,000 kilograms of explosives over the next 12 months, as this, combined with the current inventory, will not exceed the licensed limit of 50,000 kilograms for the licensing year. Explanation. Scenario analysis. This scenario presents a common challenge in the explosives industry, balancing operational efficiency with stringent regulatory compliance. The need to optimize production while ensuring safety and adherence to licensing conditions requires careful planning and accurate calculation. Misinterpreting or misapplying regulatory requirements can lead to significant penalties, operational shutdowns, and most importantly, safety risks. The professional challenge lies in accurately forecasting resource needs based on projected demand, while remaining within the legal limits of licensed explosive quantities. Correct approach analysis. The best professional practice involves a meticulous calculation of the maximum quantity of explosives that can be manufactured or stored within a given period, considering the licensed limits and projected demand. This approach prioritizes regulatory adherence by ensuring that production never exceeds the permitted thresholds. Specifically, it requires calculating the total allowable production over the licensing period and comparing it against the projected demand. If projected demand exceeds the license capacity, the professional must either seek an amendment to the license or adjust production plans to remain within limits. This aligns with the core principles of the Explosives Act of Ontario, which mandates strict adherence to license quantities to prevent unauthorized accumulation of explosive materials. Incorrect approaches analysis. One incorrect approach involves simply producing to meet projected demand without cross-referencing the licensed quantity limits. This fails to acknowledge the legal constraints imposed by the Explosives Act of Ontario, which specifies maximum quantities for safety and security reasons. Such an approach risks exceeding the license, leading to immediate regulatory action and potential license revocation. Another incorrect approach is to only consider the current inventory and not the cumulative production over the licensing period. The Explosives Act of Ontario governs the total amount manufactured or possessed within a specified time frame, not just what is currently on hand. Ignoring cumulative production can lead to exceeding the license limit over time, even if individual production runs appear within limits. A further incorrect approach is to assume that the license permits production up to the stated maximum at any given moment, without accounting for the duration of the licensing period. The license specifies a limit for a defined period, and exceeding this limit cumulatively over that period is a violation. This approach overlooks the temporal aspect of the licensing conditions. Professional reasoning. Professionals in the explosives industry must adopt a proactive and compliance-first mindset. This involves 1. Thoroughly understanding the specific terms and conditions of their explosives license, including quantity limits and the relevant licensing period as defined by the Explosives Act of Ontario. 2. Implementing robust inventory and production tracking systems that monitor cumulative quantities manufactured and stored. 3. Regularly comparing projected production and demand against licensed limits. 4. Seeking timely amendments to licenses if projected needs exceed current allowances. 5. Prioritizing safety and regulatory compliance above short-term production gains.